group, but I think what they're going to talk about applies in some fashion to all of us. So I hope you enjoy it, and I'll turn it over to Timothy and David.
Thank you, Stuart.
Yep.
Appreciate it. And thanks for the invite and the beautiful forum to come meet and eat breakfast with you fine folks. I got the better view than you do. You're looking at me. I'm looking at a handsome crowd and beautiful women and a beautiful river out that window. But it is a pleasure to be here. We do appreciate you all taking some time out of your busy schedules on this Friday morning to learn a little bit more about risk management, and in particular this thrilling, exciting topic of contractual risk management. It is an interesting topic and something that is important to have some level of understanding with. And I no doubt you all wouldn't be here if you didn't already have some level of understanding, because I don't think you can be a successful contractor without having some level of understanding on this subject. But what David and I hope to do is just kind of do some level setting, make sure you have a good sense of what the best practices are, what the industry is doing, and hopefully give you some things to think about as you go back into the workplace, go back into your office and start thinking about your contracts, your certificates of insurance, and so forth. Just one step backward, again, my name is Tim Buckley. I'm from Chattanooga, Tennessee. I have been with Liberty since 1981. In October of 1981, I got married. In December, I graduated from MTSU, and December 28, 1981, I started work with Liberty Mutual. So a lot happened in the last quarter of 1981. Happy to say I'm still married to the same woman and still employed by the same employer. Have 4 kids and 3 grandkids, and I've been in Chattanooga since 1984, and I guess we got about 10 inches of snow in some places Wednesday night. It's the fastest snow that I've ever seen, and it was pretty much gone by Thursday afternoon. So I was a little concerned I might not be able to get up here, but didn't have any trouble yesterday afternoon. And David, do you want to?
Yeah. My name's David Gordon. I am based out of our Nashville, Tennessee office. Field consultant. Basically what I do is provide the on-site services, risk control services for our customers and clients, as well as do some of these training presentations. I've been with Liberty Mutual just over 10 years. Started out in the Maryland, Washington, D.C. area. I was there for a couple of years and then was able to transfer to Nashville. I grew up in Western Kentucky in Murray. I'm a Murray State grad. Not to pick on Tim, but you started your career and everything in 1981. I was born in 1980. So right off the bat, I'm going to show my inexperience in that, but that's all good fun. I'm a generalist in terms of servicing a number of different industries. Currently, my workload for the customers that I work with is skewed towards construction. Probably about 75 to 80% of the time I've spent out in the field working with clients and with customers is contractors. So that's one reason why I'm here today. I think Tim would agree with me in that this is something that I can almost guarantee there's folks in this room that know more about this than we do. We want to give you some tidbits and some bits. If you can pull a couple things that will be helpful to you, I think our job would be a success.
All right, thanks, Ed. So this is kind of the outline for the next 60 minutes or so. We want to talk about why this is an important subject of managing contracts, and we want to talk about doing a reality check, getting you to think in terms of what have you been signing, and what have your employees been signing in terms of contracts, and what risk have you been accepting, and what risk have you been trying to transfer. And then we want to talk a little bit about some strategies for you to take back and start thinking about some of the things that you're doing. So when we talk about a 3-step strategy, we're really just talking about how do we accept risk, how do we transfer that risk, can we transfer that risk, and then the insurance piece of that. So those are kind of the 3 ways to be thinking about this. And this is the only, like David said, both of us do a lot of different types of work. You know, we work on workers' comp, we work on general liability, we work on auto. We make presentation on all manner of subjects. This is the only topic where we put this slide in, just because it is a very complex topic. It's a legal topic. We're not lawyers. We don't want to practice law. Well, actually, I might not mind it, but I'm not trained to do it. So we do want to be careful about how far we go. You know, the nature of a consultant is always try to have the answer. Well, in this particular area, we need to know, you know, when we don't have the answer. And we can't write contracts, but we can talk about contract review processes. We can talk about certificates of insurance. We can talk about risk transfer. So there's a lot of things we can talk about and share with you, but we do need to be careful about, you know, how far we go. And we will always encourage you to, you know, discuss, you know, with your counsel, with your attorney, when you get down to the nitty-gritty of actually looking at your contract, changing the language in your contract, or maybe for some of you, just getting the contract might be, you know, I'm sure we have all levels of experience in here. But part of the issue is, you know, what's true in Tennessee may not be true in Alabama, North Carolina, or California, or Texas. So laws vary by state. So when you get into liability, you know, it could have been made in one state. I could have bought it in another state that I don't live in, and I go back to my home state. So you have all these different states that could be involved. It can just get very, very complex. So we will be painting with some broad strokes, and when you get down into the weeds and the flowers, you know, there is a need to consult with counsel. So I just want to make sure we kind of clarify that. So David mentioned about being a consultant. So this is an example of some consulting that we did with a customer in Alabama. This is a contractor. They're an HVAC contractor for the most part. So about 70% of their work was HVAC work, and about 30% was plumbing. And you know, their typical job is about $1 to $5 million in revenue. And they had a single-page contract in place. And you know, I make the point here that they were missing some critical provisions. So we'll have a little interaction here real quick. Let me escape out of this and open up this subcontract. So this is the contract that we saw. Now, in all truth, this wasn't my customer. This is another one of our colleagues that Dave and I work with in Alabama that shared this example with us. So, you know, I think maybe one rule of thumb, and this is unofficial, but if 80% of your contract is white, you might have a problem. So this is a little hard to read, but there's really not much here except the names of the folks. This is the work we're going to do, and this is what we're going to get paid for. So that's about it. So when we talk about some critical components missing, really from a risk transfer contractual liability point of view, there's not a great deal here that is going to protect them or transfer risk, or it's pretty much just wide open. So that's what they originally saw, or what we saw when we started working with this customer. And this is what we suggested. So these were our recommendations, was to talk to some folks, talk to your council, talk to your trade association, talk to the General Contractor Association in Alabama, talk to your agent broker, talk to the fine folks at TIS or perhaps Liberty Mutual, and get some advice. And again, that legal advice, and get a standard subcontract agreement that you can use. So if you're in the shoes of a general contractor working with a sub, this is something you can use with the subcontractor, or you know, vice versa. So that was our recommendation. We also talked to them about the contract review process, and we talked to them about certificates of insurance. So that certificate of insurance We'll talk more about that in a few minutes, but that's basically saying, if I'm the general contractor and David's a sub that I'm contracting with, I'm asking David's carrier or agent to send me proof of insurance. So that's what the certificate of insurance is. And there's a lot of details on that we need to be aware of and talk about. And have a process in place so that you know when those certificates expire, so you can begin looking for that new one to come, a month or so before that renewal. So if David's effective date is January 1st, I want to make sure I get the new certificate, before January 1st of next year. That doesn't sound like a hard thing to do unless you have 500 of these that you have to wrestle with and manage. And some folks do have literally hundreds of these, and some folks just have a handful. It's just something that's important to do. So again, looking at that contract agreement, talking with our legal folks, and looking at certificates of insurance. So what they did, well, go ahead and look at this first. So this is what they did. They went and got a standard template from AIA. They incorporated some indemnification language requiring the subcontractor to defend and indemnify our customer, or in this case, the HVAC contractor. Now, defend and indemnify, that's a whole other topic, and we'll talk a little bit more about that. Essentially, what we want to basically say here, and we want to try to be fair, is David will defend and indemnify me if something his company's work does that causes harm or injury or property damage, and we both get pulled into the legal suit, then if they had a role in it, he'll take care of my defense and indemnify any losses that I incur. So that's the contractual protection. Now here's the insurance protection. So there's a section there for insurance requirements, what the minimum limit's going to be, the additional insured status, and then they implemented a contract with a certificate of insurance review process. And let me show you what they went to. See if I can build that up a little bit. There's just two parts of this I want to show you. So Article 3 talks about furnishing a certificate of insurance, basically, with the contract. And then Section 7, and you just pass the limits. Let me show you that real quick. So this is the expectation of the coverage they'll have. And this is in, and I'll defer to Lisa and Stuart. Everything we're showing you, we zipped it on the file and sent it to TIS. So, and we're more than happy to have all this pushed out to everyone.
Okay.
We don't have it on paper, but we can email it. If you just want to see this as a reference moving forward. So then Article 7. Here we go. This is where it gets a little scary. And split between 2 pages. So it kind of starts out by saying, defend and indemnify. So that's defend and indemnify that you'll hear several times talked about. And hold harmless the owner and the contractor for everything that has happened since the beginning of creation, practically, as you read this. But the one part of this that I think brings some fairness and equity into this is when you look into the next page, where it talks about, to the extent caused by the subcontractor. So it is connecting it to what the subcontractor is doing. Now, some of these don't. Some of these don't have that. Some of these do say you're responsible for everything that happens pretty much on this job. So that contractor transferred all his risk to that subcontractor. So what this language does, from my perspective, and if any of you disagree or feel free, but is it just kind of outlines who's responsible for what, and it's basically saying if the subcontractors during the course and scope of their work causes property damage, causes bodily injury, causes some type of harm, they're going to be responsible for it. Essentially, is what this is saying. David, do you agree with that? As you look at that? So again, we've got that. We can send it to you just as an example. But we did want to start off with a real life example, with a real customer that does similar work perhaps to some of you folks. They're very successful, but this is one part of their program where they had a gap. And yes, sir.
I struggle with indemnification clauses because they're really not insurance. They're more legal matters than they are. Invariably, the insurance requirements will tie back in, says you need to insure the indemnification clause per se. And I struggle with saying, well, the indemnification clause is much broader than the insurance coverages you have. I mean, it'll take care of property damage, bodily injury. Indemnification applies to non-payment, fines, penalties, all kinds of stuff. So is any suggestions there as far as when you see, we're asked all the time to review the indemnification clause, and like I said, I struggle with that. I can look at the insurance requirements and take in compliance and what you need to do and the cost of being in compliance. But I just personally have always struggled with indemnification clauses. Right, and frankly, and that's kind of where I would have to say to my customer if they came to me is you need to talk to your counsel that specializes in contractual law. Because every state's different.
Exactly, right.
One of the slides that we'll be talking about in a few minutes talks about the different types of hold harmless and indemnification clauses or agreements, and you can lump those into three different categories: broad, limited, and intermediate. And we'll kind of talk about those and kind of talk about some things that you can pick out from the verbiage and things like that to kind of get or kind of gauge which side is this kind of favoring. And that is the trick is digging through that information, digging through all that legalese to be able to figure out, are we going to pick up the whole bundle if something bad happens, or is it a fair agreement that is reasonable for both sides? So we'll touch on that a little bit, maybe not in as much depth from a legal standpoint. And like you said, every state's going to have different statutes and different regulations.
I got one yesterday. The indemnification clause itself is 2.5 pages. And
that's why
we've been asked by, to modify our indemnity language based on the state we're in. In our subcontracts.
And depending upon what side you're on, whether you're the general contractor or the subcontractor, sometimes you've got, in order to get the work, you've got to change that and kind of give a little bit. But you've got to be cautious not to give away the whole form. And thank you. The rest of this presentation, if you've got questions or have anything to add, please feel free. I've been speaking for Tim a couple of times, but I would say interrupt us. If you've got something to say, I'm not going to get offended at all. Just say, hey, David, shut up for a minute. I got something to say. I won't get offended at all, okay? So 10, 15 minutes into the presentation, we're already looking at contracts and we're looking at legal language. Pretty exciting, right? Let's step back a little bit and kind of talk about why do we sign contracts? What is the purpose? We've all done it. We've all signed contracts. I would venture to guess, and maybe I'm speaking for the room, but we've probably at one time signed something or checked a box or whatever and not read through the whole document. We sign contracts all the time. If we lease property, we lease an apartment. If we participate in a softball league or something like that, you're signing a waiver. You know, if you get hurt, the park league or the town is not responsible for, you know, any injuries, those types of things. You know, downloading Windows version 7 or whatever, in order to download that on your computer, you got that big long agreement that pops up, you scroll through, you hit the check mark, and you forget about it, right? You know, that's a contract. You know, there's a lot of information in there in terms of using your data and all that stuff, and you know, downloading music, you know, anything that you do, you're signing contracts. And you've got to be aware of that stuff now. Am I the guy that's going to read, whenever I download a new piece of software on my computer, the newest version of Excel, I read through that and get my attorney to review it? No. But we've got to recognize those instances where we need to kind of go through it with our legal counsel and say, hey, you know, are there things that could really come back and bite us if something does happen? If you bought a house, you know, on closing day, you go, you sign a stack of documents. This, you know, how many people, and I'm one that doesn't, you know, how many people are sitting there and taking 4 hours to go through every single line? You know, they always say, well, that's a standard thing. Okay, well, all right. I guess I'll be all right. You know, and it's fine until something bad happens. You know, we sign things and we go through it, and it's fine until that bad thing happens. And the importance of going through this and looking at this information and making sure that it's fair is for those bad times. It's the paperwork piece that is going to be great 99 out of 100 times, but it's going to be that one that could really be detrimental. So why is it important? We talk about knowing what your liability is, what your skin in the game is for different situations. We've got a lot of different costs associated if something bad does happen. We've got defense costs. We've got costs to make the things right. So if there's a claim or if there's damage done to a third party, if we're not, if we're the general contractor and subcontractor in the scope of their work, whether it's poor quality, whether they contribute to an accident to a pedestrian or somebody in public, if we don't have the right contracts in place, we may get pulled into those types of lawsuits and things like that. And even if we win, unfortunately, we kind of still lost, because from a defense cost standpoint, from a potential reputation standpoint, and you know, if you're named in a big, high-profile lawsuit, sometimes the news doesn't cover the result of it 6 months, a year down the road, and that mark on your reputation as a company has already suffered in your community, and also in the insurance world. If a company is involved in lawsuits very frequently, even if they win every single case, the insurance company may not want to do business or may want to charge you higher premiums because they're taking into account all of the defense costs associated with all those lawsuits. Again, even if you win those, there's still some potential negatives to that. A big problem we talk about is I didn't know. I didn't know what was in the contract. And about 30% of Liberty Mutual's general liability claims go into some of those indemnification or risk transfer type problems, all that contractual paperwork stuff. Again, some of those things that are either being done incorrectly or aren't being done at all. So one thing that you can do is to kind of do some of the things that we're talking about from a risk transfer standpoint. We'll talk about additional insured agreements. Tim will talk about insurance protections, indemnification, hold harmless, all that stuff. So we'll talk about some of that stuff. The good news is, if you put an eye on this stuff and you're aware of the things that can go wrong, and some of these simple best practices, we can protect ourselves as contractors and companies and businesses from a lot of the bad stuff that could happen. So one example here, just another one where we talk about a roofing contractor. And they've got jobs all across the country. And maybe they don't have operations in a certain state or a certain geographic territory, so they hire a subcontractor to do a certain job. And that subcontractor, in the course of preparing for their work, they're loading materials onto the roof. Something happens, they don't secure the materials down. Materials fall off the roof and hit a person walking by, hit a pedestrian, hit a third party. During the investigation piece of it and some of the discovery, it's discovered that there's no indemnification agreements between the primary or the general contractor and the subcontractor. So the roofer or that primary contractor is named an additional insured under the sub's GL policy, but there was no process in place to check certificates of insurance. And when the problem happened, when the claim occurred, that's when we go back and we check all that information, check all that paperwork, and it's discovered that all the certificates of insurance for that subcontractor's GL policy were expired. So both companies are named in the lawsuit. And in terms of results, since there was no indemnification clause in there, and the subcontractor didn't have any general liability insurance, that roofer or that primary contractor owns that claim, owns all of the damages responsible to make that pedestrian or that third party whole again. That roofer is primary for the recovery, so for all the monies and things like that. So going through and having that certificates of insurance review process and having that management process in place could have discovered that before they hired that subcontractor and before that subcontractor got on site to do any work.
So just another example we wanted to share with you is a company, and this happened in Chattanooga, hired a service company to work on their outside lighting. Lighting on the corner of the buildings, primarily is what we're talking about. So, I say a service company might be a little strong when the reality was he was just a guy that could do this work, but he really wasn't a company and really didn't have insurance coverage. And I heard this as we were eating breakfast. I heard someone actually say this. We used to just do a handshake, and that was good enough. And that's not the case today in most situations. So no one ever asked for certificates of insurance. So he was doing work on the lighting. No one had gone inside to the service panel, to the breaker panels to cut off, lock out the power. So he was working on an energized circuit, and he was electrocuted. Again, you always have to think about state law. So he's basically considered an employee of that company that hired him to do this work, and was not a private contractor. So basically, it was just treated as a workers' comp incident on that. Those folks that hired this independent worker, and they basically ended up having to pay about $250,000. So from a claim point of view, is that lucky or unlucky that we paid as much as $250,000, or we only paid $250,000? Pardon? Cheap or expensive? Could have been worse. Could have been worse if this went a different route and got in front of a jury, perhaps. To me, this is kind of a fairly straightforward, simple story, and also simple controls. But we see this all the time, folks that get hired to do some work on your premises, maybe to mow the lawn, And the more locations you have, the more exposure you have to this, where your managers might be out there hiring some casual workers just to do some work on your premises. So essentially, really all we're saying here is just make sure that we're checking certificates of insurance to make sure folks have coverage.
What year was that? Because I thought Tennessee state law allowed independent workers as long as they were sole person, no employees.
This is probably about 15 years ago.
Money isn't the current law that if you
If
can
you're a
hire
contractor, you've got to have
for one person.
0 people.
Okay.
Can't you exempt one person?
You can exempt yourself, but that
Exempt
doesn't,
yourself.
I don't think that stops you from having the requirement of having workers' comp.
For your employees, yeah.
Right.
But
For employees,
yourself.
yeah.
Or
For
even
yourself.
subs they hire.
But it has to be on file with the state of Tennessee. You can't just say, I'm exempt because I'm an owner.
Right.
You've got to exempt yourself.
But if he was exempt, with the state of Tennessee, sole employer, no employees,
You shouldn't be able
he
to go after.
shouldn't be able to go after.
In fact, I think there's criminal penalties if he tries to go after it, if he's exempted himself.
Mhm,
So we've been talking about risk transfer and acceptance, and the acceptance really is just just making sure you're aware of what risk you are accepting by making sure what your contracts say. If you don't understand them, get some folks to help you interpret what they're saying. But essentially, you know, when we speak of risk transfer, we're essentially trying to determine and identify what risk have I transferred, what risk have I accepted, and that's done usually, you know, through contractual language. And there's a tension between all these different parties, you know, between a general and a sub. You know, trying to transfer risk into this direction, and then over on this side, the general contractor may be accepting risk from the owner. It happens in retail, hotel, healthcare, everywhere you go. So that whole idea of risk transfers is done through contractual language, and you know, that's why we talk about as you get into that contract, being as specific and clear as you can be as to what that risk transfer is going to be, what it's going to look like, the work that you're going to do, who's going to do it, and so forth. So these are some elements, you know, on that one blank contract that I showed you earlier on, where it was mostly white paper and just a few words on it. We talked about some critical components we're missing. So these are some pieces in your contracts that you want to be aware of and want to be looking for, and they won't necessarily have these headings per se, but in some form or fashion, you want to look for language for indemnification. And you know, on that 6-page contract I shared with you from Alabama, I think is where it came from, I was just kind of interested. You know, it's on the computer, and even though it's a PDF document, you can still do a search, a word search. So all I did was search for the word, and all I put was INDEN, and that word indemnity showed up. You were sitting with me, it was like 10 or 12 times in that contract. So actually, that's kind of a quick way to find out where some of these things are, because again, there's not big arrows or headings necessarily. As you saw in that contract, it was just numbered 1, 2, 3, 4, you know, and through to like 12 or something. Though there should be a section on being an additional insured. Where's the whole harmless clause? Is there one? What are the insurance coverages going to be? What are they going to talk about? What are the limits going to be? So these are, you know, 4 key parts in that contract that you want to be on the lookout for. You want to search and find in the contract where they are, what they're saying, what risk you're transferring, what risk you're accepting. And you know, it should clearly state what are the safety requirements going to be, what are the controls going to be, what are the guidelines for acceptable performance. What does good look like, in other words? What are the expectations? What are the expectations of our managers? Who's going to manage the safety program? What will I be required to do as a sub as far as safety meetings? Are you as the general going to be running safety meetings that I need to participate in on a weekly basis, on a daily basis? What about site inspections? Who's going to do those? how will that work? So basically, just kind of thinking about that safety program, and instead of having 8 different programs on a job site, everyone has the right to have their own safety program, but if you're in the shoes of the general, I would want to make sure they at least meet the minimum requirements of the program that you have. If they want to do some additional things, that's fine, but at least outline what the minimum requirements are. And in these days and times, my experience has been, more and more this is an issue as you come onto job sites. Your experience model is being looked at, your safety program is being looked at, your losses are being looked at, before contracts are signed, before you're brought onto a job site. So we're seeing more and more where your safety program is becoming a critical part of getting jobs and staying in business.
Any practical advice? I mean, somebody will sign anything you put in front of them sometimes, but then if they don't comply with it, if they don't attend the safety meetings, if they don't, what kind of advice do you have for them?
So, I mean, if you're a general contractor and there's a requirement for, let's say, weekly safety meetings, I guess I would say if it's a requirement and it's part of the contract, then it's a requirement. And do they have the resource to do it would be one question I would ask. If not, what can we do to help them facilitate those meetings? Are we going to do the meetings? We've got resources we can help with. So, I don't know, David, any thoughts?
A lot of times you want to make sure you have the next steps outlined in the contract. So if you fail to follow these things, here's what's going to happen. Whether it's holding pay, that type of thing. And like Tim said, having those things in place to let's figure out what the issue is. Are there things that are preventing you from attending? Is it scheduling? Is it not having enough folks on site? The other thing that you can do is prior to awarding those bids is to outline those expectations and have that meeting to communicate that. Here's what is expected of you before you sign this document. We encourage you to have your attorneys review it, and so that you are crystal clear what the expectations are before you get into the project, before you pick up this work. Because it is going to be an expectation. It is going to be something that we expect you to do, Mr. or Ms. Subcontractor. So communicating that beforehand is a big concern.
You recommend something as simple as, like on the contract, having both parties initial each page? Is that any more?
I don't know.
I don't have an opinion on that.
Yeah, I don't know from a legal standpoint. I can't speak to that, whether that would hold up more or less. I'm not qualified to say. I'm not sure from that standpoint. Somebody in the room may have.
Are you required to do that with the owner?
No.
No.
We have that on some of our contracts. They'll go through it initially, not immediately.
Yeah. And I always, from a personal example, again, I use when I purchased my first house. I was a younger person and just not knowing that you're just so overwhelmed. And from a business standpoint, I would think that it would be taken a little bit differently. And not to say that I'm an irresponsible homeowner or anything like that, but you could really get yourself in a bind if you don't look at that. As the subcontractor or as the general contractor for the owner, not looking at that stuff. And I sympathize with your situation in that there's only so much you can do with the other party of communicating those expectations. But having those
I mean, to the extent though, and I'm basically saying to the extent that there are, say, safety-related issues that the indemnity and the insurance policies, are going to be things that, are going to be there, a resource there to indemnify. Yeah. Like I said, we've all been in situations where there's only so much you can do. you know, and you're 3/4 of the way through the project, and you're not gonna, you know, change horses at this point. So you just try to manage your way through and hope nothing happens, but you don't ever want the finger pointed back at you that, well, you know.
And from a risk control standpoint, I think we would recommend that pulling out the contract and going line by line from a legal standpoint is probably one of your farther down the list options. If you can work that stuff out without getting the attorneys involved and kind of figuring out, like Tim said, what is the issue? What is the challenge that's preventing you from meeting these expectations? And I know that sounds great when we're sitting here, you know, drinking coffee and things like that versus out in the field. You know, but you know, you're right. Sometimes that you have to go line by line and say, you know, here's what we signed. Here are the expectations. We talked about this before. Hopefully your attorneys went over it. You were clear on those things. You know, what are the next steps? You know, if you're not doing that. That's an issue.
I just want to add two quick comments. As far as resources go, and if someone's not doing something, is it they won't do it or they can't do it? If they can't do it, we can perhaps teach them how to do it. And I would encourage you. I don't know all the resources that all the carriers provide, but there's a lot of resources out there to make safety meetings real easy. I mean, we pretty much can give them to you. It's just a matter of pulling out a piece of paper, pulling it up on your iPad, and having a 5-minute toolbox meeting. Everything that you need to say is right then and there. So, and then the other point I wanted to make is it's easy for me to say. So I'll just say in terms of a parent and parenting skills, you can expect what you accept. So if I continue to accept something over and over and over again, then, well, that's what I'm going to get. So part of it too might mean is just thinking about that. What have we accepted in the past, and then if you try to change that, that's hard, and that takes energy and time, and it's not necessarily an easy thing to do, but just something to think about. So yeah, just moving on. Again, just some points to be thinking about as you're looking at contracts and thinking about your own contract. Most of this has to do with the safety piece of it and the insurance protections in it. And we've already started talking about some of these things. It can also include disciplinary actions. How are we going to settle disputes? If you ask me to do some additional work because this contractor this sub isn't doing their part, and I'm in charge of housekeeping now all of a sudden. How will I get paid for that? How will that work? You want me to do an inspection of the fall protection, the guardrails at the end of each shift. So things might change throughout the course of the job. How are we going to handle those type of things? At what point are some of these difficult, hard things going to happen? How specific do you want to get in writing with these type of things? At what point, does this contract get terminated? So I'm not suggesting that the people sitting in this room necessarily have to come up with the language for these things. We're asking and suggesting as you go through your contract, as you're sitting with your counsel, with your attorney, and you're thinking about rewriting your contract, just bring these up for topics of discussion. And does this make sense for you all? Is this something you need to look at, to put some language in? David? No, this is me. Yeah, we arm wrestled over this one. I just got off of the phone with one of our GL experts. I mean, that's all this guy does. He lives and breathes it. Because I was asking him a question about one of my customers who does a certain type of business, and their customer was asking them to manage a gas station. And these people know nothing about managing a gas station, but that's what they're being asked to do. So I called them, Jim. I said, hey, what do you think of all this? And they're not going to own the gas station. They're just going to manage it. They're going to run a little convenience store. They're going to take people's money and so forth. I have to apologize. I took a Claritin this morning, and I never take antihistamines, and it has completely dried every saliva I have in my entire body, and I'll never take one of those again. But anyway, that's why I'm up here with my glass of vodka, I mean water. But Jim got real passionate about this subject. He said they have to have a written defense and indemnity agreement. That this owner is going to be responsible in this case for really what we were concerned about was pollution. Those underground storage tanks leaking, that type of thing. But in a broader level, in respect to your world and in the contracting world, really what we're suggesting and talking about, and this was in that language I shared with you on that second contract I showed you, what looked to be the better contract. It did talk about the sub defending and indemnifying the general contractor or the owner, or whoever that other party is, but they connected it to the work and the performance of that subcontractor. So, but sometimes these can be brutal. These can be where again, you are being held responsible for everything, things you don't even have control over. That's not what we're suggesting at all, and David will talk a little bit more about that. But just in theory, just making sure we understand what we're talking about with the language. When we talk about defend, we're talking about pay the cost of the attorney's fees associated with the indemnities defense. So David's the owner, I'm the sub. He's the indemnity, so I have to pay to defend him, is essentially what we're saying. If something my work did got us both pulled into the legal system. And then indemnify, it means to pay damages. Whether it was a court judgment or through a settlement or whatever, however that came about. So this is basically, I think that's pretty straightforward. It's essentially legal fees, and this is for the harm that was caused, to the person. So that's defense and indemnity agreements, in a broad way.
Should there be an issue with where if we're the owner? Sometimes, there could be limits on what, if you're the sub, that your policy legal fees might cover. Mm-hmm. There could be limits on those, could there not?
You mean on
my
my insurance?
If I'm looking to your insurance policy, yes, to pay my legal fees,
right?
Because you don't have anything to pay them.
And so that's where these can be a negative in that case. And it may be a limit on, and it may not just be you. Right. There may be a couple other people I'm defending, right, but yet I have limits. So, right, so that bucket of money that is for defense or legal fees has to now be divided about 3 or 4 people. So on the surface, this may seem like a good thing from one person's point of view, but then just like you described, and that's an excellent illustration, maybe not, because of that, if it's not equitable and fair, then it's not going to work as you thought.
Standard GL policy, and Frank really saying standard, but the standard GL policy, the defense is outside the limit, and really is unlimited. Now, pollution policies will have a limit typically, and some more and more GL policies, maybe with specialty subs, are tied in, but typically your limit is for the property damage, bodily injury.
Yeah.
The defense is outside that, and if they spend $2 million to defend it, so be it.
Unless it's an eroding policy. Eroding policy, the attorney fees eat into the limit.
And you're starting to see that more and more.
We had $1 million policy, and it settled when there was $950,000 of legal fees.
Does anyone remember, this is, almost 25 years ago, between here and Chattanooga, midway between is the Hiwassee River, and there's a paper mill there. Mm-hmm. You remember the fog accident?
Oh, yeah.
Well, guess who insured that deal? And so it was like $1 million limit with millions more of that defense costs. So we spent, $5 million to pay $1 million. basically. So that can be kind of crazy.
So in terms of some of the risks and some of the negative consequences for not doing some of the things we've been talking about, here's a list of them. I'm not going to read every single one of them. You can read all those, but forcing to assume liability for acts of others, including full negligence of the other person. So that's where some of those indemnification and hold harmless agreements or clauses can come into play if you have, in one of the future slides, we talk about broad agreements where if I'm a subcontractor and Tim is the general contractor, if there is a poor agreement between the two parties, there may be an opportunity for him as a general contractor to assume all liability for things that I do wrong. So if I have poor work, poor quality work, or if I contribute to an accident like we talked about with that roofer example of that subcontractor dropping materials, and if they didn't have any sort of indemnification agreements, Tim as a general contractor could pick up all of my bad stuff in essence. So there's a real opportunity from that standpoint. Agree to liability not covered by insurance, not covered by the company's insurance. So there's a lot of different things, and Tim's going to talk about insurance coverage and insurance protection, things like that. Owning the whole thing, ended up with all the liability for all of the parties involved. So kind of taking responsibility for everybody's bad actions or everybody's claims or things that come up. Kind of talk a little bit about defenses and negating defenses that you otherwise may have. So basically signing away any of the defense arguments that you have because of poor contract language. Told you I wasn't going to go through all these, but I am on that. The last one that I want to talk about is the second from bottom, and I'm not going to spend too much time on this, but for me, this is a confusing concept. Lets their own employees collect workers' comp, then sue them through someone they indemnify. And then we're going to rely on you a little bit to kind of illustrate an example. So if I'm a subcontractor employee and I get hurt, there's an opportunity for me to get workers' comp benefits through my employer, right, subcontractor. But if there wasn't anything in place from an indemnification agreement, there may be an opportunity for me as the injured employee to go through and pursue that general contractor or that other party if they're partially negligent. Is that?
Yeah, so you're pursuing me,
Yeah.
but because of the agreement we have, you've accepted all the risk for me, so now it's coming back to you through a liability path.
That's confusing for me. Sometimes I have to think through that a lot. Sometimes I don't get anywhere with it. So we talk about, we've already mentioned these concepts. We talked about them, hold harmless, indemnity clauses, and insurance agreements, typically in the form of additional insurance. So we'll kind of go a little bit more in depth on these types of things. And I'm going to read this first bullet point and try and stay with me. I challenge you to, anybody that's not familiar with some of this stuff. Parties to a contract agree that the indemnitor will indemnify and defend another party, the indemnity, for damages arising out of the indemnitor's performance of the contract. I'll give you like 15 or 20 minutes, or at least I need 15 or 20 minutes to kind of go through that and go, okay, what's this going to do? It's not necessarily, you need to know the concept behind this, maybe not necessarily the terminology of it. And here's an example. You transfer responsibility to a subcontractor to defend and indemnify you against claims involving the subcontractor's work during the scope of the project. The big thing with that is basically making the subcontractor responsible for their work. And if they do something not up to par or not up to the expectations, they need to be responsible for it. A lot of people shook their head and said, yeah, that first one, I understand. You guys are better than I am. And that last piece in that bubble just kind of gives you example in terms of language. That, you know, that's a little bit easier to, for me, it's a little bit easier to understand than that first.
And that was similar to what was in that contract.
Yep. So in terms of indemnity clauses or hold harmless agreements, some of the things that we talk about is the acts which give rise to the obligation. You know, what are the things that would kick this into place? Negligent acts, omissions, you know, regarding the scope of work, those types of things. What losses and what expenses are covered? You know, claims, losses, attorney fees, defense, that type of thing. What is the notice of occurrence or the notice to trigger the indemnity? You know, what are the things that would put this into place? And then Tim already mentioned the duty to defend, you know, those types of things. And then, you know, financial limits. You know, what are the limits in regards to here's the most money that's going to be involved in that. I've already mentioned these, or at least referred to those. When we talk about this hold harmless or these indemnification agreements, they kind of fall into three different buckets. Broad form, intermediate form, and limited form. And unfortunately, the contract is not going to say, hey, this is a broad form or this is an intermediate form. That's where we get our legal counsel involved to kind of figure out. The language that's involved here is putting us in this category. And you can read those. Broad form, agree to hold the indemnity harmless no matter who's at fault. You know, so those are probably ones that are favor one side versus the other, right? The intermediate form is kind of a little bit more towards the middle. Assume liability except where the loss was caused by the indemnity's sole negligence. So there's a little bit more with that. The best form that kind of evens things out is the limited form. And any sort of contract, we want to try and come to a happy medium between the two parties, right? You know, so both people are relatively happy. Now again, that's not necessarily a reality 100% of the time in the real world. But if we could, it would be fair to both sides, right? So limited form, we assume liabilities to the extent that they exceed the indemnity's comparative fault. The next piece, the next point, excludes claims and losses resulting from the negligence, whole or part of the indemnity. So this is something where it's kind of breaking it down almost into like a percentage of fault. You know, so if the subcontractor or one party is responsible for the majority of the negligence, well, they have to pay the majority of the damages.
What's comparative fault?
I'm sorry?
What is comparative fault?
Assumed liability. You're kind of looking at it from. Go ahead.
Well, it's like a percentage.
Yep.
If it's determined that you're 40% at fault, then you would hold them harmless or indemnify them for that portion of your, whatever you're deemed to be
Who
at fault.
determines that percentage?
Courts usually.
Yeah.
And another thing, this is really important for, particularly as you go work in other states, because in some states, it's actually, if you have an indemnity agreement that is broader than what is allowed in that state, then the courts will throw the entire indemnity agreement out. So you would think that, okay, if I went with the broadest form, then it would check down to the next. No, that's not how it works. It's thrown out completely. So you go from having what you think is full protection to having no protection or indemnification if you're not, you know, within the laws of that particular state. So make sure your attorney's looking at that at least annually to make, you know, in each state that you're in, that is an okay indemnity agreement.
I mentioned before, I said, you know, I'm sure every company is probably can be a resource to give you those indemnities state by state.
Exactly. And that's why they do it.
And that's why they want
You know, so Yeah, no, that's a good point.
Can I go back to something real quick? We mentioned a little while ago the notice of occurrence, you know, for an event. How do we need to, I mean, there's got to be some time limit on that at some point, or you would think. I'm sure there's some statute of limitation on that. You know, if an event occur, you know, if you're the general, something happens, you don't know about it for 2 years. You know, all of a sudden, you know, you get a lawsuit on your desk. What, in terms of contractually in our language in our contract, is there something there we need to consider from an insurance standpoint to?
I guess I would ask the question first in terms of, is it something that that is inherent in the project where you need time for it to rise up, or is it something to where it didn't get reported at the time and then?
I'd have to go back and look at our contract, but I'll bet you there's at least there's a 30-day provision in ours probably that says you got to notify us of any event.
Yeah, like I just.
Now, like you said, maybe it couldn't.
If it's a
you won't
complete
know that.
operations type of thing where, mold or something like that, where there may not be the opportunity for it to manifest itself until, 2 years down the road or however.
Yeah, but I'm sure
that's a
our
whole
language says
different
30 days
system.
after the evidence of the occurrence, probably.
I got you, yeah, after the issue's discovered,
Probably.
yeah.
I would guess that's what ours says. Should there be any other consideration in that?
Mark, the definition of occurrence is probably one of, if not the most seminared topics. I mean, when you go to all these, because you got manifestation, when it manifests itself, you've got multiple policy, there's like the whole asbestos thing, when that first came out, it was actually determined that every policy from first exposure through damages was responsible. And so most carriers have tried to limit their exposure to the policy period when the occurrence first happens. Okay, so that brings the question of how do you define occurrence? And so it is tough. I mean, I think in your contract, I think there should be certainly language that gives you an opportunity to rectify or fix and to be notified within a certain reasonable amount of time.
So as a general, you definitely would want in your contract the ability to go back to the insurance that was in force at that time.
At the time you built the project?
In other words, if there was a construction defect, okay, that's there from the point in time the work was performed. It may not manifest itself for 3 years, but in our contract with whatever subcontractor performed that work, we'd want to make sure that his insurance that he had at the point in time he performed the work would be available to us once we came.
Yeah, but you can't do that. What you have to do is rely on the completed operations. You're banking on the fact that that subcontractor is still going to be in business and is still buying insurance. And part of the general liability policy is for completed operations. So, we've had claims where there was one last year where sprinkler line caused some flooding. It was an installation problem. The sprinkler contractor was out of business when the occurrence happened, and the general contractor carrier paid that claim. So there's no way to contractually make sure that that policy that's in place at the time the work is being performed is going to respond. Now, you're doing it a little bit by having an occurrence-based policy as opposed to claims made. The claims made form is going to respond whatever policy is in place when the claim is made.
So we would always want an occurrence-based.
You will always want occurrence.
And your contract requires completed operations for a period of time. We always recommend whatever the statute of repose is for that state.
Right. Which in Tennessee is very favorable. It's like 4 years. But you get into some of these other states, it's 10, 15 years. And so, yeah, that's a tough.
But in Mark's case where the sub was still in business, that sprinkler was still in business, still had insurance, that would be primary, wouldn't it?
Yes.
Yeah.
Hope, I mean, hopefully. If assuming you've got the additional insured status completed on, it's very complex.
Yeah, and you know, when you talk about comp, you don't usually hear words like hopefully and maybe, and it probably will. It's kind of definitive to some extent, but when you get into GL, it's like holding a bowl full of Jello without the bowl. I mean, you know, it's just complicated. It took you a while to get that, didn't you? So the insurance piece, in my mind, is a little bit more straightforward. We've been talking about the contractual piece. So this is the insurance piece, and we've got a lot of insurance professionals in this room, and you've got access to a lot of good advice. And there is a connection between the contract and the insurance piece, because we do outline, you know, some of the expectations in the contract. You know, there are some specific things to think about. So think about the AM Best rating is one question to ask of the carrier, or you might want to stipulate that, you know, your carrier has to have such and such an AM Best rating. Think about the limits that you're going to want to see. What are your limits? They want to at least match those limits. We want to talk about additional insured coverage, limited to AFLOP exclusions, deductibles. So the additional insured essentially means my coverage will apply to you when you're an additional insured. A named insured, and the way I think of a named insured is you may have a company, you may have a couple companies, a couple different names, but it's still under one umbrella. So each one of those might be a named insured. Do any of the insurance folks want to chime in on that subject, named insured versus additional insured? Did I do that okay on that?
Sure. There's a bit, yeah, it's a big difference. So to have that additional insured status, it should be done by endorsement. You know, there's various forms. ISO is insurance service organization that supports the insurance industry. The carrier may have a form that they use. As an insured, you're subject to the terms and the conditions. So you know, that should be stipulated and outlined in the endorsement. So read and understand that.
You say endorsement, you're talking about the certificate of insurance?
Well, so the certificate of insurance, and we'll share an example of that, but it's my understanding that there is another endorsement for
Well, that's one of my problems, and we're one of the contractors that's got thousands of these in our office.
Yeah.
And there is nothing on a certificate of insurance that tells you what the exclusions are, what the policy really says. And you would have to hire 10 people to go through all the insurance policies of every one of those certificates of insurance to really know what you're getting. And that's frustrating. I don't know why they can't do a better job of listing what you're really not getting. Because the certificate of insurance looks great, we got it, check it off the box, move on.
Yeah.
Well, when something happens, you say, oh, that wasn't covered. What do you mean it wasn't covered? You know, read your policy.
We're going to pull one up here in just a second, and we can kind of go through it in a little bit more detail. The broker accord form, and you know, so we're about to talk about certificates of insurance. Accord is another agency that supports the insurance industry. So they develop forms and things that are suggested for use. So that's where that certificate of insurance form ultimately comes from. You know, that gets into adding exclusions, limiting coverage, the additional insured status, subject to the terms and conditions of the policy. We want to make sure it's equal to our own. You know, partly for this reason, we don't want any pocket deeper than another. So we want to make sure that there's equal coverage between the different parties. So this is a certificate of insurance, and David will talk about this, but in the package that we'll email you, there's a document. This document is in that.
And like Tim said, we've got a PDF that kind of gives you some information in terms of certificates of insurance. I'm sorry that this doesn't show up as clear as we wanted it to, but it kind of breaks down what are the different sections of a COI. What are some things that you're looking for in terms of going through and reviewing them? And you're exactly right. This only says so much.
And David, I want to make sure.
Yeah.
This, I forget which, I think you just brought it up, and you can't read it here, but this is where it talks about occurrence or claims made.
Is there any way that you could easily tell if you're getting a fraudulent one?
Call the agent.
Yeah,
I mean,
that's right.
Seriously, in the top left,
Yeah.
it lists the agent. And
Yeah,
you
that
can call
would
and
be
say,
the only
"Hey,
way
is
I would
this-
really
Is this
know."
a legitimate,
Yeah.
is this one of your clients?
It's happening.
I'm surprised we don't get more calls from people wanting to verify that. That agent information is there, and, if you're having trouble getting an answer on something, if they have, call the agent, or call us, and we're happy to call the agent. And usually, we can get the answer, might not be the answer we wanted or had hoped for, but that's really, Mark, the only way, because you do see fraud. I mean, you see,
Oh, yeah. Are we coming?
there's been guys arrested just standing outside Home Depot handing out, fraudulent certificates for $50. And so, there's no real good way to tell. The other thing I wanted to point out, more of a practical thing, if you've got a smartphone, NCCI came out with an application. It's a free application, and everybody in this room should download it. And it's I think 33 states that are under NCCI participate, and it's real-time data, and you can type in the name of a subcontractor that's working for you, and it will tell you whether or not they have workers' compensation coverage in place and who the carrier is. So that would be a way right there, Mark, if you have doubts, you punch their name in, and if it doesn't pop up, then that's a red flag.
Of course, that just addresses work comp.
That's just work comp.
There's no way to verify that.
There's no way to verify liability other than call the agent.
Well, but if
And you're right,
comes
there
back
are.
and at least that would give you an
I mean,
indication.
I had a client send me a certificate, and the insurance company had been out of business for 5 years.
Well, and the other thing, on the forms, those change periodically.
Right.
Is there that's got RC 8608?
Well, no, that's our reference note.
That's our.
But yeah, I'm not sure, the Accord, the previous slide talks about the Accord form. I'm not sure what the number is.
Is there any moniker on the form itself that would tell you it's an out-of-date form?
And I'm not sure about that in terms of.
Yes, there
It'll give
is.
the form number and the date it's published.
2011 was the latest.
So that would be
Change.
the current one.
That doesn't mean it's still gonna be fraudulent.
No, I understand that, but you know it's
Sure,
fraudulent if it was the wrong day. If it was an Accord
Well, I mean,
form.
there's some companies that use those certificates,
Okay, all right, so there's no requirement to use it.
not that I'm aware of.
All right.
And one of the things,
I'm trying to avoid reading the policies, so let Mark do that.
How many contractors are there? How many of you ever read an insurance policy from front to back? I tried it one time.
Don't ask agents that.
I'm gonna ask my agent to read it.
I'm gonna have to file them.
one of the things that, I'm kind of jump ahead and then I'm going to go back to,
You just went back.
no, there you go. No, I'm good.
Yeah.
This is the COI form. stating the cancellation notice accordance to policy. The insurance company that insures your subcontractor, or whoever is providing you that certificate of insurance, if it's not stated in that COI, they have no obligation to inform you, the general contractor or the owner, that Joe's Plumbing Company doesn't have insurance because it got canceled or non-renewed or anything like that. So again, I'm sorry that this doesn't come up, but there's a box in here, and I'll read it. It says it's a cancellation box, and we want to make sure that we're stipulating that, and I'll read the document, read the verbiage. Should any of the above described policies be canceled or non-renewed before the expiration date thereof, the issuing company will mail 30 days written notice to the certificate holder named to the left. So from an additional insurance standpoint, this would be your company, right? So the subcontractor or the company that's providing you this certificate of insurance, their name is going to be up here, agent and the name of that company, and this is you. If you have that in there, then the insurance company needs to send you notice that Joe's Plumbing is being canceled. So if you don't have that, that gets into some of those situations where you may not know that Joe's Plumbing one day doesn't have any GL coverage.
We have to be careful there too, because sometimes it doesn't even list it, and you have to get it through an endorsement.
Okay, yeah, yep.
They don't do that anymore, yeah.
Get what through
Most
endorsement,
people have to get an
the
endorsement.
additional insured?
An endorsement to show their
From a
cancellation
cancellation
policy.
notification.
Or additions, or either one.
Well, yeah.
Well, the latest edition of the certificate just says, notice of cancellation will be provided per the policy provisions. Now, how broad is that? Seriously, I mean, that's what it says, and that's all that's all old language. So what we've had to go to over the last couple of years since they made that change is actually, when that's a requirement in a contract, either for a general contractor or subcontractor, we have to endorse the policy to specifically provide 30 days notice cancellation to whoever that either owner or general contractor is, and list the specific endorsement form, because there's new laws. We're legally not allowed to put anything that's not exactly verbatim on the policy on the certificate. And so, everybody in this room probably deals every day with these box checkers from either the owners or the GCs that have a list of what they need, and if it's not exactly what they need, they're not going to accept it. So it's an education process. I think we're farther along now than we were 2 years ago, but it's educating the attorneys, the owners, the general contractors as to what can and can't be on a certificate and what endorsements to look for and to ask for.
And a lot of contractors now you have endorsements that are blanket additional insured as required by contract. So you've got to be sure you've got your contract and you're signing that contract.
Some of those points that you just mentioned kind of go into that box checker piece of it, managing your certificates of insurance program. And like you mentioned, a company that handles thousands of these, that could be quite a task. And having something in place, whether it's an Excel spreadsheet or a tickler file for when your subcontractors or vendors, when their certificates are coming up, for
Most accounting software lets you do that. That's getting to be the easy part anymore. It's knowing what's really in it.
Yeah.
I think too, one of the things is your certificates of insurance, when you get the renewals, and a lot of things are getting missed. When you first get your insurance certificate for a project, it's usually pretty accurate, but when you get the renewal, they don't have all those things again, and you're going to have to request those endorsements again.
Yeah, we see a lot of customers that can struggle with some of those things of just the follow-up piece. And that's something that I don't want to even say that it's simple to do. It's easy conceptually, but executing on that and getting those vendors and those subcontractors to provide that to you is quite a task. The other thing, real quick on this slide is, set job or location limits to ensure the policy isn't exhausted. So if you've got multiple locations or multiple jobs going on, and we don't want something bad that happens at one project to exhaust the limits for the whole policy, and then these other projects have no coverage on those. So work with your agent to kind of figure out is this fair to whichever party you are. In terms of certificates of insurance, establish one person or one group of folks to collect those and maintain those. We already talked about there are things that you can look for, and we've got information that'll be in the documents that we send you that kind of give you some best practices of things to look for, and we've already talked about a lot of those. That follow-up piece we've already mentioned too, in terms of those vendors and those contractors, when they're, because contractors, most of them are going to have different effective dates for their policies. So it's not just in December we get everybody because they're going to be renewing on January 1. Unfortunately, that doesn't happen. So everybody's got different policy effective dates. From a paperwork standpoint, obviously, having that software, if you got accounting software or something like that manages all that, you're at a huge advantage, because this could get really tedious and really cumbersome. From a record retention policy for contracts, certificates of insurance, work orders, things like that, this says maintain contracts as long as possible. Minimum of 7 years, but defer to there's different statutes of limitation for each state. So you got to be familiar with those types of things. We talked about the 30 days cancellation notice in the contract. And other things in place, and we've already kind of exhausted that discussion in terms of endorsements and statements in the certificates of insurance.
We've talked about a lot of these, David, and I just want to be cognizant of the time.
Yep, okay. Yep, we talked about it. Yep, you're right. Scope of work, safety requirements, the ratings. The last piece, passing down those insurance agreements if you've got third-tier subs, and even farther, making sure that these requirements that you require are passed down and communicated and are in place for any of those additional tiered subs. From a time standpoint, again, I think we've mentioned most of that stuff.
Yeah, so I mean, essentially these are summarizing, in the beginning we talked kind of about a threefold process, and we talked about, accepting risk and just evaluating what risk you are accepting consciously by, going through contracts. And then we talked about the contractual piece, and then we talked about the insurance piece. Now those two get intertwined with each other, but they are separate discipline and separate subjects.
One wording that just flashed on there, we didn't talk about, well, I think it's even primary non-contributory. Most insurance policies have another insurance clause that says if there's other insurance, we're going to be proportionate to that. But making the subs be primary non-contributory kind of overrides that clause in the standard CGL policy.
Thank you. Thank you. This just kind of goes over, we mentioned the certificates of insurance document that's in there. We've got another a resource for you that we'll send along. That RC 5349, that's just Liberty Mutual's way of tracking our resources, but it's a contractual liability. It goes over a lot of those things that we've talked about today: hold harmless agreements, indemnification, certificates of insurance, all those different concepts. It's a 5 or 6 page document that's pretty handy. And in the last couple pages have a kind of a self-assessment on your process that you can kind of walk through and kind of evaluate your own way of doing those types of things. And we just had a couple pictures at the end. We probably won't spend a lot of time on these, but we just wanted to give you some real quick examples, and you can look at the presentation on your own when you get it. But we had a bunch of different scenarios or things that could potentially be fodder for discussions on who's responsible for taking care of these things that may be safety issues to other contractors on site or the general public. And we were going to talk about those things, but for sake of time, we'll kind of skip through this a little bit. But we've got, attractive nuisance type things, a retention pond that has no fencing around it, has no protection, or this is just a torn up sidewalk, on the block of the street with no protection. What is causing or what is preventing, a pedestrian just to walk through that job site and get injured. And
So who's responsible for that protection?
Yep.
Who's responsible for traffic control? Who's going to maintain it? Who's going to inspect it? Who's going to take a picture of it at the end of the day to make sure it was there at the end of the day?
And obviously, those responsibilities ideally are outlined in those contracts. Who's responsible from a contractor standpoint to do that. Similar situation with open excavations.
I don't know, you see the guy in the jacket, so, that's a pit right there. I don't know if you can see that from where you're sitting, but he's just walking right along.
And we don't know if this is a member of the public that has just kind of walked through the job site because it's a shortcut, versus going around the fencing. It may be, I know, on college campuses and where, things like that, where you've got active construction, a lot of times we see college kids just scooting through the job site, because it's quicker. They're running late for classes or whatever it is. So, that's a huge exposure perimeter protection for the job site. Similar situation in terms of housekeeping and things like that on the project.
So the first thing is the control of it, which really has nothing to do necessarily with some of the things we're talking about. So that's the first and foremost, is control that exposure so that fella can't walk there. But then we're talking in terms of who's responsible for this, who's the fall protection, the housekeeping, and so forth.
Next picture is showing scaffolding. A lot of times on projects, one contractor is responsible for installing and kind of owns the scaffolding, if you will. And there may be an opportunity if it's the block masons or the brick masons using the scaffolding. Well, maybe the glass guys need to get up there and do something on that scaffolding. So maybe after hours they come to an agreement, a handshake agreement. Hey, go ahead and use the scaffolding. It's our scaffolding, but there's opportunities to kind of flesh that stuff out as to, well, the glass folks need to do their inspections. They need to bring things on. Bring a professional that knows about scaffolding on site to do the inspection to make sure that it's legit and is up to par. From the standpoint of the masons that own the scaffolding, they don't want to be responsible for the glass guy that falls off or doesn't know how to work on the scaffolding or recognize issues or things like that. So there's a lot of different things. We can also talk about like cranes or heavy equipment where multiple contractors are sharing those pieces of equipment. There's a lot of potential liability issues associated with that.
But that's a crane failure on the right, and these folks are running away.
Underground utilities, hitting those types of things, whether it's gas lines, water mains, even cable, communication, telecom, that type of stuff. Having different inspection procedures in place. Again, making sure that anybody that's doing work on that site is responsible for, who does the utility call, the one call to get the service out there to mark the utilities. Is there a policy in place for doing hand digging when you're getting so close to the marked lines, all that kind of stuff, and making sure that is spelled out so that we're not missing those types of things. The next picture, pile driving operations. You got vibration, you got seismic damage, whether it's actual damage or perceived damage. So who's responsible for taking pictures of the surrounding areas and documenting, hey, there's a crack in this house, their foundation, before we even started doing any blasting or pile driving or any of those heavy vibratory operations, that type of thing. I think we've talked about mold. That's what this picture is here in terms of completed operations, moisture, control, things like that, having that spelled out. Sometimes those things don't manifest themselves until the building owner gets in, occupies the space. You know, it may be X number of months or years down the line before we discover that. You know, this one is pretty easy to figure out. But if it's behind the drywall or behind the walls, it may take some time before you figure out that there's an issue. We've already talked about complete operations coverage and things like that. And the last one on here, if I'm going too fast.
No.
Okay. The last one on here is from an environmental standpoint. If it's a fuel tank that's damaged, I think Tim mentioned underground fuel tanks, that type of thing. You know, from whose responsibility is it? Who owns that tank? Whose responsibility is it to dike the area or to provide, you know, secondary walled or multi-walled containers so that if a leak does happen, it's not going to leach into the ground and get into a huge environmental issue. I know we kind of went through those fast. I apologize, but I want to be aware of folks' time. Do you have anything?
Again, we appreciate y'all's time, and did want to just close and make sure, are there any questions or comments that anyone wanted to bring up that we haven't addressed? And as I mentioned, the folks at TIS can push this out to you, all these documents and references. And again, thanks for your time.
All right, well, we will, a couple things just real quick on that. I think one of the common themes and one of the things we'll emphasize is work with an attorney that understands construction, and work with an agent that understands construction, and work with a carrier that writes construction, because it's very complex. We don't expect you all to leave this and know everything about contractual liability, and we deal with it every day, and we don't know everything about contractual liability. But it's, if you can surround yourself with people that understand it and do it every day, I think it will help you. So we'll break for about 10 minutes. Restroom, we got some snacks and drinks, and help yourself over here, and then when we get back, we'll have Sean King with CIC Services to do a presentation on 831B captives. So take a break.
Around, so if I need to stand behind the mic, let me know, but hopefully I'll move around and you can hear me okay. Thanks to our friends at TIS and Liberty Mutual and everyone else for having us here. What we're going to talk about today is captive insurance companies. And captive insurance companies are an increasingly popular tool, one of the fastest growing sort of risk management tools out there, especially the smaller variety of captive insurance companies, which is what I'm going to focus on today, the so-called 831B variety of captives. As we'll learn, 831B refers to a section of the Internal Revenue Code, not unlike 401k, which everybody's familiar with, 401k plans. 831B refers to a section of the code that provides some really unique tax advantages for certain types of small insurance companies. So you'll probably hear a lot about captives now that I mention it. You may even hear about them from your accountant from time to time. There are huge tax advantages, and we'll certainly won't shy away from those. At the same time, I think it's critically important that folks do captives for the right reasons. The IRS, as we'll talk about, does not like captives. That's the bad news. The good news is they've lost nearly every single court case in the last 30 years where they've tried to attack captives, including two very important ones in the last, say, 9 months, well, a year at least. One of which was a case called Rent-A-Center, and another was a case called Securitas. So we'll talk about that. We'll talk about how to protect yourself, but the best way to protect yourself is just to make sure you're doing captive insurance companies for what the IRS considers to be the right reasons. And the right reason is risk management. And the good news is, if you're in the construction business or you're a contractor and you are successful at all, you've got all kinds of risk management issues. You've already been talking about some of them. We're going to talk about them today on a much more broad scale and talk about some risks that you may not even really have contemplated before and how captive insurance companies can help you protect against those risks. So if we stay focused on risk management and we let the tax benefits just flow from that, we're going to be fine if and when we are ever scrutinized by the IRS. So don't let all the stuff you may see online about the IRS attacking captives and that sort of stuff, don't let it scare you. There are captives being done out there. They're being done abusively. They're being done for the wrong reasons. They're not dotting the I's and crossing the T's. And yes, the IRS is scrutinizing those, but done right, they are perfectly legitimate transactions, and they've stood the test of time. Our firm is called CIC Services, Captive Insurance Company Services, and we are to a captive insurance company what a TPA firm might be, a third-party administration firm might be to a 401k, or maybe even to a health insurance plan. If we're doing our job right, we make setting up and operating your captive insurance company really seamless and really turnkey. It's as easy as setting up and operating a retirement plan for your company is. In fact, it's a lot easier than setting up and operating a retirement plan for your company is, simply because you don't have all the monthly sort of payroll stuff. So what we're going to talk about may sound very complex, and there is a lot of complexity to it, but you, as the business owner, as the owner of the captive insurance company, are largely insulated from that complexity. Just like when you set up a 401k plan, you're largely insulated from all the different testing and all the different filings and everything else that goes on with your 401k plan. So what we're going to talk about today is a concept that we call just enterprise risk management, or ERM. This is a buzzword in the property and casualty space lately, and it means different things to different people, but what it means to us is really just approaching the risk of your business from a much broader perspective than you typically would. If we were to sit down with a blank sheet of paper and start brainstorming with the typical contractor or the typical construction company about all the things that could go wrong that would cost you money, it's going to be, honestly, a fairly small percentage of those risks that you're currently buying insurance for through organizations like Liberty Mutual or through brokers and advisors like TIS. The vast majority of the risks of your business, whether you fully contemplate it or not, you're just assuming. You are what we call informally self-insuring those risks. Well, as we'll learn in a minute, if you will formally self-insure those risks through your own captive insurance company, you're going to get a lot of very important advantages that you don't get through the current approach. What are some of those advantages? Well, one's just a stronger business model. By contemplating these risks to which you're exposed, by thinking about them, by considering the impact on your business, and by taking steps through your captive insurance company to protect against them, you're going to end up with a business that's more likely to survive, more likely to weather economic downturns, more likely to be able to handle life's uncertainties. A large part of that results from the improved risk management, potentially improved cost control. As we'll see in a minute, the insurance company itself, the way we do them anyway, they're typically highly profitable entities. And the retained earnings, the wealth that builds up inside that insurance company really is going to function for you as a loss reserve. It can be used in any number of potential ways. Ultimately, it can even be used down the road if you don't have major losses to fund your own retirement with in a very tax efficient way. Tremendous asset protection. If it's done right, all the wealth, all those retained earnings that build up inside your captive insurance company are going to be protected from both your personal creditors and the business's creditors. We actually had several contractor clients set up captives in the early 2000s. things were going and blowing, and then literally, seemingly, almost overnight in 2007, 2008, 2009 timeframe, many of them just had the rug pulled out from under them. Many of them bankrupted their development companies, but the wealth, in some cases millions of dollars that had built up in the captive, was protected. They were able to bankrupt and then days, weeks, months later liquidate their captive insurance companies and use that wealth to essentially start over again. And many of them are very, very successful today, once again, thanks in part to the capital they were able to protect inside their captive insurance company. We talked about advantageous tax treatment, which kind of last for a reason. In most people's mind, I'd be lying to you if this wasn't more toward the top of the list for most people, but we want to keep it in its proper place. Let's let the tax consequences flow where they may. And then estate planning opportunities. We won't have time to get into that today, but if you are a business owner and you are already in a position where you're probably taken care of, you're not going to need a lot of additional wealth to get you through the rest of your life, you can use a captive insurance company as a way of transferring millions and millions of dollars of wealth to the next generation without what I'll call excess profits. These are profits that don't need for now, but each of these businesses has $1.2 million a year. The business on the left is doing it the way that probably most folks in the room are doing it now. They're taking that $1.2 million a year, each and every year for 10 years, and they're paying tax on it. And they are leaving the rest of the money invested in that reserve, retained earnings, or some other reserve. And they may be using a portion of that money to buy all the regular sort of insurance coverages, all the basics, right? Property and general liability, employee benefits, workers' compensation, automobile, all the typical sort of stuff. At the end of 10 years, doing it this way, they essentially will have had these coverages for the 10 years, and their reserve would be about $7.3 million that they would have accumulated. The business on the right takes the same $1.2 million, continues to purchase all these insurance from the same folks they are now, perhaps the good folks at Liberty Mutual or elsewhere, but in addition to that, uses some of that $1.2 million to buy lots of other different types of insurance from their own captive insurance company. Spending the same $1.2 million at the end of 10 years, they've had all of these coverages for a 10-year period, and their reserve at the end of 10 years is $13.3 million. So if you have the opportunity to be the business on the right, most of us would prefer to do that rather than to be the business on the left. And the good news is most of us who at least have the cash flow do have this opportunity, because as I said before, in this particular industry, there's plenty of risk. We don't have to worry about there not being enough risk to insure through a captive insurance company. So, what does the ERM, Enterprise Risk Management process, look like? I basically already talked about that. Really, kind of the initial steps is to work with work with your folks at TIS, and really begin to brainstorm once again about all the different things that can go wrong that can cost you money. And we'll have a long list, and it's only a small portion of those that fall into this core risk category, things that you're already insuring for. But there will be lots of other risks that we'll identify. We typically label those as operational or strategic risks, where you're not covered. These are things like subcontractor defaults, or contract cancellations, or administrative actions, which we'll talk about, or reputational damages, or any number of other things that you're typically not going to have any coverage for, or if you do, it's usually going to be relatively modest in amount, and perhaps with lots of different potential exclusions. And so this is kind of a depth of coverage chart when we work with the typical business. This is overly simplified, but something like this is what we develop. We identify these core risks that they're already insuring for, and then for that business we'll identify a series of operational and strategic risks that they're either not insuring for at all or are significantly underinsured for. And let me just talk about what a few of these might be. Administrative actions is potentially a big one. Administrative actions is the risk of some governmental agency, state, federal, or local level, coming in and auditing you, investigating you, suspending your license, jerking your license, doing something that costs you a lot of money. This can obviously happen in construction with environmental sort of issues, potentially. It can happen in any number of other industries. You wouldn't think that it would be that prevalent, but even a company like Gibson Guitar in Nashville, Tennessee, twice had the Environmental Protection Agency come in and seize its inventory, alleging that they had imported protected hardwoods for use in manufacturing their guitars. Now, twice they went to court, twice they got their inventory back after millions of dollars in litigation fees and having no inventory to sell, or less inventory to sell for many, many months. You can imagine how costly that was for them. But that's an example of an administrative actions type of risk that's typically not going to be covered by those core types of insurance policies that most of us always have. Another one, reputational damages. This is the risk of something going wrong, perhaps even beyond your control, that damages your reputation such that folks no longer want to do business with you, at least as not much as they would before. I can't think of any real-life construction examples. The folks at TIS may be able to help. We've only had one claim in this in the few years we've been doing it, and it was actually a physician in rural Georgia. He's an orthopedic surgeon. There's really no other orthopedic surgeons within about a 90-mile radius of him, so he's incredibly busy. People travel from all around to get their surgery done with him. And one day, the sheriff's department shows up and escorts his physician's assistant out in handcuffs. Anybody want to guess why? Pain medication, exactly. He was dealing pain medication out the back door, exactly. And it was all over the paper. It was a rural community, they didn't have a lot of excitement going on, so the local papers running all these news stories really impacted his practice. He had to give a bunch of money to charity, hire a PR firm, do lots of other things to rehabilitate his reputation over time. But there was about a 9-month period where his patient load dropped off considerably as a result of the bad publicity that was received from that. So that's just an example, and you can think of analogies, I'm sure, to that in the construction and contracting business. When we get out to the strategic risks, these are usually real existential threats. These are things that if they go wrong could just flat out typically put you out of business. Business interruption is a big one. Business interruption is a very broad term, and really, if you're thinking of it from an all perils sort of perspective, it's anything. It could be anything. It could be the power grid going down for a long period of time so that you're not able to operate. It could be pandemic disease outbreak. It could be anything, supply chain interruptions, anything that really disrupts your ability to conduct normal business operations. Contract termination is a very big one. This is the risk, and this certainly some contractors would have this risk. This is the risk of some major contract canceling or perhaps going bankrupt. And you're sitting there, big time exposure, and now you're not able to get paid what you thought you were going to be able to get paid. This applies a lot to dealerships of any type. Automobile dealerships, if you think about it, their entire business hinges upon a contract with the manufacturer. And as General Motors dealers learn, the manufacturer can and does sometimes cancel those contracts. John Deere dealerships, government contractors of all types have significant potential contract termination exposure. So those are just a few of these sort of high impact but hopefully low frequency sort of risks that could have very detrimental impacts on our business. They're usually not insured through third-party commercial coverage, in part because getting these types of coverages would normally be too expensive. Many insurance companies don't offer these types at all. When they do, they often have lots of significant exclusions and limitations in them. And when they don't have that, those that do offer them and don't have lots of significant exclusions and limitations, the premiums are just typically way too high for the typical small business to justify, in their minds, incurring that sunk cost of buying third-party commercial insurance. But what if you could insure these operational and strategic risks through your own insurance company? An insurance company where you would essentially retain the profits and you would get some amazing tax advantages in the meantime. Well, that begins to have some pretty interesting appeal if you think about it. So let's talk about what a captive insurance company is. It's just a corporation. You go down to the Secretary of State's office, you form a corporation like any other. But that corporation takes one additional step. It gets a license to operate as an insurance company. Not as an insurance broker or an insurance agent, but as an actual company. And the primary purpose of that company is going to be to write, in this case, various types of property and casualty insurance back to your operating business, your construction or contracting business. Now, as we'll see in a minute, you can't sell insurance only to your related businesses, usually. I don't want to get too far down that road because I have a whole separate section on that. But think about it for now. As you're setting up a company, that company gets a license, and its primary purpose is going to be to sell insurance back to your related operating businesses, construction company, equipment companies, anything else that the business owner may own. Because the same economic interests own the insurer, the insurance company, as own the insured, your operating businesses, you can think of this as just a very formal way of self-insuring some risks. Now, why would you want to engage in these formalities? I think we alluded to some of them previously, but I'll analogize it to a retirement plan. Why formally save for retirement through a 401k plan or a profit-sharing plan when you could just informally put money in a mutual fund or bury it in the backyard? And the answer is obvious, right? I mean, you get significant tax advantages when you honor the formalities. You get significant asset protection. All the money that builds up in your 401k plan is completely protected from your creditors, even in bankruptcy if it's done right. So we get lots of advantages when we do things formally that we don't necessarily get when we do them informally, and that certainly applies here with captive insurance companies. They've been around since the 1950s. They've been challenged time and time again by the IRS and others. The IRS has consistently lost, and they are done right, they are perfectly legitimate risk management structures. So, there are huge tax advantages to captives. Let's talk about what those are. So, there is a code section 831B, and this code section governs small insurance companies. That's the term the code uses. We call them captive because the insurance company is kind of captive to the operating business. Its primary purpose is to insure the risks of a related operating business, so we call it a captive. But the tax term is just small insurance company under code section 831B. And what code section 831B says is that if you are a small insurance company and you meet a couple criteria that are relatively easy to meet, then you can elect, when you file your tax return, to pay a 0% tax on your underwriting profits. So the captive insurance company pays no tax, 0% tax rate on its underwriting profits. So what are underwriting profits? It's premiums received less claims paid. So if I take in $1 million of premium this year, and I'm insuring contract cancellation risk and reputational damage risk and all these other things, and I get lucky and have no claims, to make my math easy, that's $1 million of underwriting profit this year that I pay tax in a 0% tax bracket on. But your operating business, the construction company, the contracting business, it gets a deduction when it pays premium to your captive insurance company, just as if it had paid that premium to Liberty Mutual or State Farm or Lloyd's of London or some other insurer. So you get a deduction when you pay the premium, and the captive takes that money in a 0% tax bracket. You're literally moving up to 1.2 million a year. That's the maximum amount you can take in and still qualify as a small insurance company under 831B. You're moving 1.2 million a year out of your left pocket, your operating business, where it's exposed to taxes and where it's exposed to creditors and where it's exposed to lots of different risks, and you're moving it into your right pocket, the captive insurance company, where it's insulated from all types of creditors with the exception of claims that would have to be paid on any policies that it writes. And it's insulated from taxation, 0% tax rate. Long and short of it is, for every captive insurance company you do, and it is possible to do more than one, but for every one you do, you're going to save between $500,000 and $600,000 per year in combined federal, state, and potentially local, depending on where you are, income taxes. That's if you're doing a $1.2 million captive. So $1.2 million is the maximum. What's the kind of the minimum? Well, the minimum to make doing these economically viable is probably $250,000 a year. If you're not going to be paying at least $250,000 a year in premiums to your captive, then all the cost and the trouble of setting up and managing this insurance company is probably not going to be worth the time and effort in the long run. So, but if you do have at least $250,000 a year of free cash flow that you can sock away on an income tax deductible basis, then doing a captive insurance company can make a whole heck of a lot of sense. So we already talked about these benefits of a captive, and this is what it looks like once you form your captive insurance company. So now you've got these core risks that you potentially continue to insure through third party. If you're buying these through a third party already, there's a good reason. You don't want your own balance sheet assuming these risks, right? But these are risks that you're usually already assuming anyway. You can formally insure all of these operational and strategic risks through your captives, and you're not assuming any more risk the day after you do that than you were the day before, but you're getting a lot more advantages the day after you do it than the day you were before. By contrast, if you were to replace these risks, these insurance coverages that you're currently buying through a third party and carrier with the same coverage that you purchased through your captive, now you've truly changed your risk profile. You're truly assuming more risk the day after you form your captive than you were the day before. So for that reason, that's typically not the approach that we take. There are others out there who form captives and use them to replace third-party insurance. That's not our methodology, at least not in the early years. Rather, we take kind of a three-stage approach. Some clients will only ever, they'll do the first stage and just continue there. They'll never get to the second. In fact, it's probably most clients. A few will get to the second stage, and a small percentage may get to the third stage. So the first stage is what we'll call maybe years 1 through 3, 1 through 5 of your captive insurance company's life. And in this stage, you definitely, in our view, only want to insure these operational and strategic type of risks that we talked about before. You don't want to replace typically core insurance risk. And the reason is your captive's balance sheet's just not big enough in those early years to take on that kind of risk. Now, 3, 4, 5 years down the road, once you've got $3, $4, $5 million built up in your captive insurance company, then if you want to, and you don't necessarily need to, many clients don't, but you may choose at that point to begin to kind of layer some of your core risk with risks that you purchase through your captive. Maybe, for example, you would increase your deductibles through your commercial third-party risk and insure those deductibles through your captive insurance company. Or maybe you would cherry pick a couple of third-party risks and begin to replace them, at least in part, with insurance through your captive insurance company. And then finally, in the maturity stage, this I would say is, 8 to 10 years into it, you've got a big balance sheet potentially in your captive. At that point, if you really wanted to begin to peel off some of those third-party risks and really write them through your captive, some businesses will choose to do that. I would say, in our experience, though, it's the definite minority, a small minority. Most of the time, there are good reasons why you're going to want to continue to buy third-party insurance for those core type of risks. So, these slides I can flip through fairly quickly here. So once again, this is kind of what it looks like. If you do this and you did it for 10 years at that 1.2 million a year rate, you're spending the same amount of money before as you were after, but you're going to get much more insurance coverage, and you're going to end up with a much greater reserve because of the tax savings primarily. Tremendous tax savings, and that's mainly explains the difference between the 13 million and the 7 million over a 10-year period. So don't get too hung up on this slide. Instead, kind of focus on my words here for just a second. Many clients at this point are like, okay, what's the catch? This just seems too good to be true. And in many ways, there is no catch. We'll talk about what you may at first perceive to be the catch, but I think you'll conclude, as I have, that it's ultimately a feature and not a bug. But if there is a catch, it's that your captive insurance company can't insure only your businesses typically. Now, there is an exception to that under IRS guidance. If your captive insurance company, or if you have 12 or more businesses, 12 or more business entities, all of which can purchase insurance from your captive insurance company, then it's possible in that scenario, assuming a few other criteria are met, to have your captive insure only your related businesses and nobody else's. That's not true for most clients, and even for some clients where it is true, they nonetheless will choose to do it the alternative way, which is to participate in what's called a risk distribution. So there are lots of clients out there, lots of folks out there who want to form captive insurance companies who don't have these 12 related businesses, and they don't want to break their business into 12 pieces just to skin this cat. So what do? Well, they simply work with a common attorney, a captive attorney. We'll talk about the couple that we use here in a minute. But they'll work with a common captive attorney, and that captive attorney will create a risk distribution pool. Essentially, it's a you scratch my back and I'll scratch yours. In other words, I'll buy some insurance from my captive, and I will buy some insurance from your captive in exchange for you buying some insurance from your captive and you buying some insurance from my captive. Now, the risk distribution pool that we use most commonly today has about 100 participants in it, and it's a 51-49 split. So the risk distribution pool assumes 51% of any claims. The related captive assumes 49%. So if you had a $100,000 claim, you had something happen, a reputational sort of issue come up, and you needed to hire a PR firm to help rehabilitate your reputation, and it cost you $100,000, so you file a claim under your reputation policy issued by your captive insurance company. Well, your captive insurance company would pay $49,000 of that $100,000 claim. The other $51,000 would be borne by the other 100 companies that are participating in this risk distribution pool. Now, if they all paid the same amount of premium, because the liability gets shared in proportion to premium, so to make my math easy, if they all paid the same amount of premium, you divide $51,000 which is the pool's share of your claim, by 100 companies, what do you get? 510 bucks each, right? So each of those companies would essentially write a check for $510 for their share of your $100,000 claim. Now, all this happens behind the scenes. It's all coordinated. That you're not getting actually 100 different checks. You're actually getting one check. It all happens behind the scene through escrow accounts and other sorts of stuff. But ultimately, your captive bears 49% of the loss. The pool pays you for the other 51%. Now, are those other captives thrilled that they had to write a $500 check to pay your claim? Probably not. But do they really care? Each of them probably saved $500,000 this year in taxes, right? So any claims they're paying with money they would have paid to Uncle Sam anyway. And to really drive that point home, let me use an extreme example that would actuarially be virtually impossible. The biggest claim we've ever seen was $400,000 claim. But I want to assume an example where we have 10 different unrelated insurers all hit maximum claim in the same year. Max claim on most policies is $1 million. Most policies have $1 million policy limit. Some may have 2, some may have 3, but usually it's $1 million policy limit. So that's $10 million in claims that come in from unrelated parties. Well, essentially $5 million of that is going to be paid by their related captive insurance companies, right? So you don't care about that. You only care about the other $5 million that's going to be borne by the risk distribution pool that you're in. So $5 million divided by 100 different companies in the pool is what? $50,000. Now, are you thrilled to write a $50,000 check out of your captive? No, but you saved $500,000 in taxes this year alone. So any third-party claims that you end up paying, and I used a very extreme example where 10 unrelated parties out of a pool of 100 all hit max claim, all in the same year. I mean, exceedingly unlikely. Even in that extreme, egregious situation, you're stroking a check for $50,000, which is less or about 10% of the tax savings you realize that year alone.
What type of claim is the $400,000 claim?
I don't even know. It's a good question. That was another.
I'm just curious in real life what types of claims because it sounds like the idea is to insure things that you don't have claims on. So I'm curious what you see.
Well, it's to insure things that are low frequency. Yeah. Real risk, but low frequency risk. So claims that we've seen loss of key customer. So we actually have a client, much like TIS, who's in the insurance brokerage business, lost a key customer, and we filed a claim for loss of key customer. We have claims for general liability. I personally was in a partnership with a business partner, and we separated, and there was a settlement as part of that separation. And I ended up filing about a $75,000 claim related to that, related to my captive. We see claims for, actually we've not seen any claims for reclamation bonds, but we often have reclamation bonds being done through captive insurance companies.
Yeah, I was going to say, you said business conditions was a claim opportunity. Let's say this weather that we've had for the past 2 weeks. Maybe 6 or 8 weeks ago when you were ramping up for your job that was supposed to happen this 2 weeks, you put a lot of resources and time and wages in that you've had to still incur, but you've not been able to work on that job for that 2-week period. So if you had an insurance policy in place to cover business conditions, could you file a claim to say cover the weight, the salaries and your overhead and your equipment costs that you weren't able to cancel for that 2-week period where you weren't able to work?
Essentially, yes. It would depend on whether you had purchased that particular type of insurance or not under the business conditions.
Yeah, so if you did the business conditions insurance, now we've had 2 weeks of downtime, you could file a claim to your captive to recover some of your salary costs and your equipment costs that you incurred that you couldn't get rid of for that period where the equipment and your employees were not able to be
That's right, and even beyond that, through business interruption and the like, you can recover lost revenue. So it's not just hard dollar expenses that you incurred necessarily that you can claim for. It can also be loss of revenue that resulted from some contingency that was unforeseen. So in this pool, just so you know, these are, of course, low-frequency, high-impact sort of risks that are typically insured in the pool. Claims have historically run around 5% of premiums. So you can expect in general that you're going to be paying about 5% of your premiums out in third-party claims in a given year. And eventually, you're going to file claims of your own, in likelihood, if you do this long enough, and you're going to recover at least a portion, maybe all, in some cases more than all, of your cost for paying claims to third parties by ultimately having those third parties someday reciprocate and pay claims back to you. That is, after all, the whole purpose of insurance, right? To spread risk. So this risk distribution pool is actually something that's a requirement of the law. The courts have held that an inherent attribute of insurance, if this is real insurance, so that you get a real tax deduction when you buy it, that the insurance company has to distribute risk among multiple insureds. If there's no distribution or spreading of risk among multiple insureds, the courts have held this is not insurance, this is just a reserve. This is just a self-insurance reserve. So the risk distribution pool is the way of achieving that. The risk distribution pool that I just described is actually, there's all different types. Some are very aggressive, some are conservative. The one that I just described actually is specifically designed to fall within the IRS safe harbors. So it should be as bulletproof as it can be from an IRS perspective. The IRS has provided in 2 revenue rulings safe harbors that say if your risk pool looks like this or meets these minimum requirements, then we agree not to challenge you based on insufficient risk distribution. One of those requirements is more than half of the risk has to be borne by the pool. You'll see some insurance arrangements where maybe only 30% of the risk is borne by the pool. So you file a $100,000 claim, $70,000 gets paid by your captive and only $30,000 by the pool. That probably is still okay. Court cases have actually said that is okay, but the IRS can technically still challenge that, and you can get in an argument with them because it doesn't meet their current safe harbor. So these are the 2 revenue rulings, 2002-90, 2002-89. So one question that frequently comes up is, okay, this is fabulous, but what do I do with all this money? I mean, I'm going to be building up, right, maybe $13 million or more over 10 years in my captive insurance company. What do I do with it? Well, every insurance company has profits, and every insurance company, if they're doing their job, they're going to find a smart way of investing those profits. So one of the things that I think makes our firm different than a great many of the competitors who do what we do is most of our competitors focus only on the liability side of the captive insurance company's balance sheet. They're really good at underwriting the policies, at pricing the policies, and by the way, that's a good point. You don't get to just make up the premium that you pay for these policies, right? You're going to have an independent third-party actuary who prices the policies for you. And that they're going to issue a thorough actuarial opinion, and that opinion is going to serve as the basis for your tax deduction. So it's important that you use a good, competent actuary, that they do good work, and they issue good, thorough opinions. If you're working with a good captive attorney, all of that will be taken care of for you behind the scenes. But once the money's in the captive, how do we go about investing it? And we do have some guidelines. The National Association of Insurance Commissioners, NAIC, has published 2 model acts, Investment of Insurers Model Act 1 and Investment of Insurers Model Act 2, I believe they're called. And they provide some guidelines on if you're an insurance company, here's how to go about responsibly managing your assets. So it's important that you give as much attention to the left side, the asset side of the balance sheet, as you do the right side, the liability side of the balance sheet. And then the domicile regulators will also have some input. They'll also want to know how you're investing your insurance company's assets. So if you form your captive in Tennessee, and right now Tennessee is one of the more favored, more competitive captive jurisdictions, thanks in part to new legislation that Governor Haslam got passed a few years ago, the regulators in Tennessee will want to approve your investment policy statement. So we would work with you to create an investment policy statement. That investment policy statement is a list of guidelines that's going to dictate how your captive is going to go about managing its assets. And essentially, there are 4 criteria that we need to think about. The first one is liquidity. The captive is an insurance company, and its liabilities are uncertain both as to amount and to timing, right? We don't know how much a claim is going to be, and we don't know when it's going to come in. So we've got to be fairly liquid. We can't really be tying the captive's assets up in illiquid projects. So that's important. What that means as a practical matter is you don't want to be putting money, paying premiums into a captive that you're going to really need for illiquid sort of long-term projects. This is money that's going to be invested in liquid portfolios. Managing volatility is also important. If you had a large claim come in March of 2009 and you had all your captive's assets invested in the stock market, you probably would have had to sell at a 50% loss in order to cover those claims, right? So we want to avoid that, and managing volatility is therefore important. If all we cared about was being highly liquid and minimizing volatility, then it would have been easy 10 years ago. We just use a short-term bond portfolio, earn a decent rate of interest, and be done with it. But today, if you use a short-term bond portfolio, you essentially earn no yield. You get no return with today's record low interest rates. So earning some interest is important. This is a for-profit company, and we want to be able to make some money. We want our assets to grow. And then lastly is tax efficiency. I said before that the captive pays tax at a 0% rate on its underwriting profits, but it pays regular C corporation tax rates on all other income. It's investment income, interest, rents, royalties, dividends. Those are going to be taxed at regular C corp rates. So constructing an investment portfolio that makes use of very tax efficient investing is going to be an important part of managing your captive insurance company. There's several ancillary benefits of a captive that I want to cover in the last few minutes, but before I do, we've got about 10 or 15 minutes left. Let me just pause and see any questions at this point about captives, how they work.
A little bit about, you mentioned Tennessee has become one of the more competitive and favored. What makes a state more attractive when choosing domicile versus, offshore? What do you look at? What makes Tennessee a good state for that?
A couple, good question, a couple things. First of all, the states love this, and there's a big race and a big competition to steer captive business to their state. It all started in the early 90s when Howard Dean was governor of Vermont, former presidential candidate. He worked with the Vermont legislature to really get the first modern captive statute. And his goal was to, of course, steer business to Vermont, captive business to Vermont, just like Delaware has been so successful in steering regular corporations to Delaware. And it was tremendously successful. Vermont has licensed more captives than any other U.S. jurisdiction. I think they licensed their 1,000th captive last year. And it's been a huge boon for Vermont. Since then, lots of other states have come in, and the states that come in really want to, for lack of a better word, undercut the others to steer business to their state. So they get the compliance burden down, they get the regulatory burden down, they get the cost of forming and operating the captive in that state down. And the regulators want to be user-friendly. And so Tennessee, being one of those states to most recently updated statute just 2 or 3 years ago, it is among the more cost-competitive states to form a captive. There's also some unique, what are called cell captive opportunities within Tennessee that really it's a fancy legal structure that just drives the cost of setting up and operating a captive in Tennessee down. So mainly it's a cost and a compliance issue. And it's getting the mix right. You can't be too lax. Utah, for example, basically had no regulations. They would just license anybody, never ask any questions, and never have you jump through any hoops. And they ended up being soundly criticized by the IRS and others for kind of being asleep at the wheel. So getting the balance right and making it business-friendly, user-friendly, and still doing an adequate job of regulating captives is the trick. And most people seem to think right now Tennessee, North Carolina, a couple other states are kind of leading the pack.
You know about how many Tennessee has?
Tennessee just licensed they just announced it, and I forget the number. They licensed 44 last year. Our firm accounted for 18 of the 44 that were done in Tennessee last year. And they were at about 40 the year before, so they're between 80 and 100 total pure captives. But because of this cell structure that I was talking about before, you can plug in essentially a subsidiary captive under an existing captive. If you count those, Tennessee's up to, I think, close to 200. So some ancillary benefits for business owners and family members. There are lots of different ways of owning the captive. You can own the captive personally. You can create you can have other business owners own the captive personally. Maybe you've got a family business in the construction and contracting business. You don't want outside owners in it, but maybe you've got some really key, valuable people you want to reward, make them kind of feel like owners. Well, create a captive insurance company, let them own it. And you can siphon off some of the profits from the operating business to the captive insurance company that some of your key employees own, and really use it as kind of a retention tool, a way of kind of locking them in, even though they're not owners in the family business per se. You can create irrevocable trusts to own the captive for the benefit of children, grandchildren, great-grandchildren. This essentially allows you to get premiums out of the senior generation's name, pay those premiums to the captive owned by junior generation, and transfer up to $1.2 million a year or more if you're doing multiple captives into the junior generation's name with no transfer taxes.
Yeah, what is that? If I missed this, I'm sorry. Kind of the entry level. We're talking about kind of the high-end benefits and where you can do it, but just for the folks in the room, I guess, is it $100,000 a year that you have to put away? Is it 50? What level just knowing the compliance costs and regulatory side of it is where it is instead of Tennessee. What would you say?
If you're going to own your own, and that's the only way I would really ever suggest doing it, is owning your own captive outright, it's about $250,000.
Okay.
There are some group captives or shared captive arrangements where you can get the math to work as low as maybe $100,000 a year, maybe even as low as $50,000 a year of premiums. But you're in business with lots of other unrelated people. Your audit risk is much more. If you are audited, the cost of complying with that audit is exponentially greater. So I would only suggest ever owning your own captive outright, and to do that, it's about $250,000.
Oh, you're talking about the gateway strip? That's right. Yeah. We'll have to use, probably have to use both of those.
So it can be a way to get profits out of a C Corp. If your operating business, the construction or contracting entity, maybe is a C Corp where you've got retained earnings, you can use the captive as a way of potentially sucking retained earnings out of the C Corp in a tax favored way, where it otherwise may be hard to get that money out in a tax favored way. You can use it potentially as an alternative to non-qualified deferred compensation plans. So all that wealth that builds up in the captive, we don't have time to get into it today, but there are ways of accessing that $13 million in the example I gave before. There are ways of accessing that money in a very tax efficient way to help fund your own retirement, or to buy out a business partner in a tax-favored way. So it can be used to fund buy-sell agreements directly or indirectly. Now, all of these I want to emphasize are ancillary. If the IRS felt like you formed your captive as a way of buying out your business partner on a tax-deductible basis, they probably wouldn't be too keen on that. But if you form the captive for the right reasons and it just happens to function as a way of buying out your business partner in a tax-efficient way, then there's really not anything that they're going to be able to do about it. We talked about the asset protection advantages. Won't go into detail here in the interest of time, but like I said before, all of the wealth that builds up inside that captive, if it's done right, is going to be protected from both your business's creditors and your personal creditors as well. That's really it. Any remaining questions? Sir?
I assume people would have a different amount that they would want to fund in any given year. So I assume you can choose your coverages on an annual basis to kind of dovetail the amount of premium you're wanting to put into it.
Great question. So the way these are usually done, the captive issues 1 year claims-made policies. So the policies expire at the end of every year, and they're claims-made, so there's no tail liability you have to worry about. So every year, you're buying new policies. And you can buy a lot of coverage with a lot of different policies, or a little bit of coverage from just a handful of policies. So yes, you can decide each year what your risk management budget is. Maybe it's $250,000 this year, but you have a great year next year and you want to do $750,000. So you have a $750,000 risk management budget. We would work with you, and the actuaries would work with you to craft a package of coverages that would spend whatever your risk management budget is almost to the penny. So it's a lot like the car insurance commercials now, where they say, just tell us how much you can pay, and we'll tell you how much coverage you get. It's kind of the same way with the captive. Tell us what your risk management budget is, and we'll help you figure out what types and amounts of coverage are the best going to spend that budget with. All right, thank you all. Appreciate it.
All right, thank you, Sean.